So, okay, it's 12:05. I guess we'll get started. This is a continuing professional development session on advocacy before tribunals, and it's being presented by Sheldon Toner and Colin Baille. If you have questions, it's probably best if you use the chat function at the bottom, and I can read them out if necessary. This is going to be recorded and will be available on the Law Society's YouTube channel for anyone who wants to review it, or if any of your colleagues would like to see it at a later date. So without further ado, we'll pass it on to Sheldon and Colin.
Thanks, Bob. Firstly, I'd like to welcome you. I'm Colin Baille. And this is a presentation on advocacy before tribunals. Excuse me, I just have to readjust my screen because pardon me.
You want me to?
All right, here we go. Here we go. This is a presentation we originally did in May of 2019, and we'll just introduce ourselves first. I have been involved with administrative tribunal work in the territories for about 30 years. I presently chair the Northwest Territories and Nunavut Workers' Compensation Appeals Tribunal, as well as the Assessment Appeals Tribunal. I'm also a member on the Human Rights Adjudication Panel and Employment Standards Adjudicator, as well chair Registered Nurses Association Appeal Panel. In addition to my tribunal work, I am a board member of CCAT, which is the Council of Canadian Administrative Tribunals, as well as an instructor for the Foundation of Administrative Justice. And I'll turn it over to Sheldon for his introduction.
Thanks, Colin. So I'm a lawyer in Yellowknife here, and as most of you know, I've been practicing here for quite a while now. It's 23 years this summer. A lot of my work has involved appearing in front of tribunals, and then since I left government about 10 years ago to start my own practice, it's also involved advising administrative tribunals of all different types. We're going to talk a little bit about the wide range of administrative tribunals that you might appear in front of in the Northwest Territories. And I've also had a chance to be an administrative decision maker myself, largely as a member of the Human Rights Adjudication Panel, of which I'm now the chair, and on some appointments by the Minister of ENR, for example, under the Forest Management Act. So between Colin and I, we've got some different perspectives from different vantage points on advocacy before tribunals. And we've both had a chance to sort of think about this from an more abstract perspective as well. As Colin mentioned, he's involved with the Canadian Council of Administrative Tribunals. I've also been involved in developing some policy and legislative change for human rights as we've moved to a restorative approach, and we've looked at using active adjudication. Colin and I have participated in forums with other human rights adjudicators, and it's interesting. I mean, with the type of work we have here in the territories, it's not like we do any one of these roles full time. So the human rights work that I do doesn't take up all of my time. I may spend as much or more time on the policy end of it than I do in the actual practice of it, just because of the volume. So it's kind of one of the features of practicing here in the Northwest Territories. You may get to do many things, but not necessarily in large volume. So that's me. I'll try to advance you to the next slide here, Colin.
Sounds good. So just to start off, and the slides can catch up, there's presently over 70 public boards and tribunals in the NWT. And this number includes a far lesser number of adjudicative tribunals, such as the Workers' Compensation Appeals Tribunal, Human Rights Adjudication Panel, Liquor Licensing Board, Rental Officer. And caseload varies dramatically between the tribunals, as few as less than 5 per year to several hundred per year. Tribunal capacity varies greatly when it comes to administrative support for tribunals, training, etc. And while tribunals are primarily moving towards merit-based appointments, there are still many tribunals without minimum appointment standards or no appointment requirements at all. There's also great differences between our tribunals for access to resources such as independent counsel, dedicated support staff, independence from the government department or agency that statutorily administers the particular act, and training of decision makers and staff. Sheldon, do you want to add anything
so I
to
think,
that one?
yeah, I think generally speaking, when you're practicing in front of administrative tribunals in the Northwest Territories, these are some things to just bear in mind, to recognize that with a wide variety of tribunals, and I use that term broadly, that we have here, you're likely to encounter a wide array of levels of experience, levels of support, levels of training that those tribunal members have had. So there's been a movement here to provide most tribunal members with training through an organization called Foundation of Administrative Justice. So a lot of people have had that training now that might not have had it 5 or 10 years ago, but there's still going to be an intense variety of experiences appearing in front of these groups. There can be, perceptions that arise from that, perceptions about the closeness of the GNWT to the appointees or some of the panels themselves. So that's one of those things we just need to recognize. In addition to those panels that are up on the slide there are some larger, more well-resourced ones like the Land and Water Boards, Environmental Review Boards, and there are also federal boards, federal tribunals that operate in the Northwest Territories, but they may not actually have a presence here in terms of an office or hearing facilities. So that kind of leads us to the next point, which is key. As with any type of advocacy, you definitely want to know something about the tribunal you're going to be appearing in front of. So this slide business is a little bit tricky. I'm going to try to move to the next one fairly quickly. There we go. I think I've got this down pat now. Okay, so know the tribunal. And up here on this slide, we have a tip, which is, not only know those things that we mentioned in terms of the wide variety of resources or support that a tribunal may have, but we recommend to know the hearing style of the tribunal, because that can have a lot to do with how you're going to present the case before it. It may be a reality that most counsel in the Northwest Territories don't specialize in appearing before one particular type of tribunal, again, because the volume may not support that. So with the courses that a lot of adjudicators, tribunal members have been taught in the territories, one of the things they're trained on is recognizing the difference between inquisitorial hearing styles, adversarial hearing styles, and prosecutorial hearing styles. And so we encourage counsel to take a look at the legislation. That's always the first place to start with advocating in front of a tribunal. And not far after that, identify which of these hearing styles you're going to be expected to follow, because there are some important differences. And with inquisitorial types of hearings, that might be something that we're less familiar with as lawyers, because much of what we do is in an adversarial context. We're proving or disproving a case in front of someone that's going to decide the merits of one side's evidence versus the other side's evidence. In a prosecutorial context, it's largely the same, but the burden is higher, the onus is higher. It's basically the same thing. Each party puts its best foot forward, and then the judge decides. So inquisitorial is a bit different. That can happen in licensing contexts where really there's nothing to be proven or disproven, except perhaps that all the criteria are met for someone to get a license, for example. A board, an inquisitorial board or tribunal might have more extensive powers to drill deeper, to investigate, to ask questions than we may be used to. So going into that type of a hearing, you might expect that's going to happen, whereas it wouldn't if you were just presenting a case. So knowing the hearing style is pretty important. And we've just given a couple examples of hearing tribunals that fall into some of those different styles. These are just examples. So for inquisitorial, there's the Workers' Compensation Appeals Tribunal, and Colin can probably say something more about that. A model I'm familiar with under that style would be coroner's inquests. The inquest is there to determine the 5 key questions about a death: identity of the deceased, manner and cause of death, something about the circumstances, and then the panel can make, or the jury can make recommendations to prevent deaths of a similar nature. It's very much an inquiry. So the questions that you might expect as counsel might be a little more far-ranging and open-ended than you might see in some of these other contexts, like a rental officer or employment standards. And Colin, did you want to say something about the different range of types of decisions? That's also something that you'll want to be aware of as counsel going in front of a tribunal.
Yeah, so in addition to the hearing style, various tribunals, their end product may vary from one end of the spectrum being the development or recommendation of policy or recommendation of outcomes. On that end may be the ombud. And it moves up the spectrum to quasi-judicial, which I believe all of the ones on the slide have a quasi-judicial range of decisions which require written reasons, but it also speaks to what kind of process that tribunal will undertake, how it's going to deal with evidence. And that will also impact on the range of decisions of any particular tribunal.
And just to maybe tie some of this together, when we speak about the wide range of tribunals, the wide range of capacity, and then the different hearing styles, it's easy to say that tribunals should theoretically have an understanding of which hearing style they are to follow, but they may or may not, or they may or may not to a lesser or greater degree. And so as counsel, you can help guide a tribunal, especially if it's one that's chaired by a lay person or someone without legal training, as to what style they should follow, how closely they should ask questions, how much they should step back and let the case be proven. So those are some considerations that also factor into appearing in front of tribunals. And Colin, I'll try to queue up the next one here.
Well, the next topic we're going to be looking at is how tribunals differ from courts. And one of the fundamental differences is that of jurisdiction. Obviously, tribunals have no inherent jurisdiction, and jurisdiction, as a result, tribunals can't order contempt or grant equitable relief. They may not even be able to dismiss a frivolous case unless the statute allows. And that's the proviso for a number of authorities at a tribunal or a jurisdiction the tribunals may have. The tribunal's jurisdiction is found solely within the four corners of its home statute. Now, tribunals will, however, generally apply the procedural fairness, and most tribunals have the authority to determine its own process. So when you're appearing before a tribunal, it's a good idea to determine firstly from its home statute what its authority for its own process is. And secondly, are those codified in any way? Are they found within a regulation, within rules of the tribunal? That's where you'll look for the procedural matters. Sheldon, did you want to add anything on jurisdiction before moving to evidence?
No, I think that fairly covers it.
Okay, so moving on to evidence then. While most tribunals aren't bound by the rules of evidence, how a tribunal deals with evidence will likely depend a lot on its mode of hearing. So a prosecutorial model being used by a tribunal would likely have stricter rules regarding evidence than an inquisitorial operating tribunal. On the screen are some excerpts from two different acts, the Human Rights Act and the Employment Standards Act, which speaks directly to this and indicating that the adjudicators are not bound by the rules of evidence. But it shouldn't be an anything goes model, regardless of what tribunal you appear before. So be quite mindful of what you put before the tribunal, while expecting the tribunal to have some flexibility. The best practice would be to focus on relevance and reliability when putting evidence before a tribunal. Secondly, tribunals will often accept a lot of evidence and sort it through the decision-making process. So while you may disagree with something going forward, chances are the decision maker will award it appropriate relevance and reliability through the decision-making process. We do have a couple of questions before we move on to the next item. The first one is directed to Sheldon. What determines the hearing style? And is it in the statutes or is it the practice of the members that determine that?
I would say it'll largely be guided by the statute. and not by the hearing members, because it shouldn't depend on the individual personalities or styles of the people. That this is something that should be emanating from the source of the tribunal's jurisdiction, which is a statute. Now, statutes generally don't come out and say this hearing or this tribunal will operate on a prosecutorial basis. So what you're looking for are the hints and signs that something falls into one of those three styles. For the inquisitorial style, you'll probably see some broad language about investigative powers, the ability to obtain information, to obtain documents. It may be in hints and signs about what remedies or what outcomes the tribunal can generate. So if it's, like the example I gave with the coroner's inquest, it's some factual determinations, but then some maybe policy-based recommendations that's suggesting something that's not determining a issue between disputants. If it's something that's if the statute sets up a dispute resolution process, that's a hint that it's something more along the lines of adversarial. Employment standards is a good example. In prosecutorial, your hints and signs are going to be things like penalties, fines. I don't think you usually see imprisonment in the administrative context, but could be license suspensions, like in liquor enforcement context. So it's probably not going to be spelled out explicitly, but it'll be spelled out in the legislation with those hints and signs. I wouldn't think it should be determined by the participants on the tribunal.
Good. We have another question. Is physical residency in the NWT mandatory for appointment as a tribunal member? I'm not aware of any statutes requiring residency. However, there's been an unwritten reluctance on the part of the Legislative Assembly or ministers to appoint people from outside of the jurisdiction without good reason. I know of several circumstances in past years where appointments were not renewed, where an adjudicator has left the territories. Sheldon, are you aware of any statutes that require residency?
I can't think of any offhand, but my observation about the practice is the same as yours.
Good. Okay, I guess we can move on to the next.
Maybe I'll just, before we do, I'd like to maybe chime in a little bit on the evidence piece here. I've had as an advocate in front of tribunals, and specifically labor arbitrations when I was doing those with the government, my experience was often that adjudicators would say, we're not bound by the rules of evidence, and we'll take whatever it is into consideration, and then decided on weight. I think as counsel, there's an opportunity to try to get adjudicators or tribunal members to up their game a little bit on that front, because although there are these relaxed rules of evidence that try to make things less formalized and more accessible to people, hearings can get bogged down if everything comes in. And I think adjudicators appreciate a little bit of guidance from counsel about things that they might be able to exclude. If it's presented reasonably in terms they can understand, like Colin said, using frames of reference that talk about relevance and reliability. A lot of tribunal members, including lawyers who are tribunal members, are not going to be able to tell you the 300 categories of hearsay or say whether something falls within one. So, but keeping it straightforward and you're keeping your objections or submissions on evidence, reasonable, I think can be useful to people who have to adjudicate. So I'll leave it at that and move on to the next slide here. I think I'm getting the hang of sharing these slides. Okay, so Colin's already covered some of the things that tribunals may not be necessarily able to do because they lack inherent jurisdiction. Charter issues are an interesting topic because some tribunals, may be asked to deal with charter issues, especially those that operate in a prosecutorial style. So you might have charter challenges on the gathering of evidence. It's quite possible that a tribunal will have to deal with that. In which case, as counsel, you're going to want to be extra sure that everybody has adequate notice, that the members of the tribunal have everything they're going to need to assess the charter issue. But you also should be aware that some charters are actually barred from addressing charter issues. And the example we give on this slide here is this one about the Employment Standards Act. So that's a no-fly zone essentially in the legislation. So like everything else, it's important to read the statute and understand the statute. In terms of other differences from the courts, in addition to looking at the home statute for the legislation, administrative tribunals might be given some authorities or powers from other legislation. The most common one you'll see is the Public Inquiries Act. So if you look at the legislation and it says the tribunal has all the powers of a public inquiry under the Public Inquiries Act, go to that act and you'll see what it can do. It may take you somewhere along the spectrum of things that a court might be able to do, but it's still governed by legislation. So you can look at that cross-referencing. Another good source to keep in mind when interpreting tribunals' powers is the Interpretation Act. I think we often forget about the Interpretation Act, but it does have a lot of good information to address issues that can come up with tribunals or before tribunals in terms of timeframes, limitation periods, service issues, how to calculate days, when things are due, filing deadlines, all that stuff that tribunals might struggle with, especially if they're chaired by someone who doesn't have legal training. You can find a lot of the answers to those things in the Interpretation Act. So don't forget about that. Might you also look to the Administrative Proceedings Act? Well, no, because we don't have one here. So if you're doing tribunal work anywhere else in Canada, you might have that resource available. You might not have that here. So good luck. But that's also something to keep in mind if you're looking at precedents from other jurisdictions about how to handle things. The tribunal that you're drawing from somewhere else might have decided things with some guidance from legislation that we don't have here. Something that sometimes people forget is that there are also, oops, I did manage to do that. I found an easier way. There are also rules and procedures that a lot of panels have. So check their website. They might have rules of practice and procedure that you can follow. They might have forms. Sometimes counsel aren't aware of those, but definitely have a look to see if there's any guidance you can get procedure-wise. The courts have rules. That's one thing that a lot of tribunals have in common. Some of the more basic ones won't, but some of the ones that deal with more complicated issues will.
You're muted, Sheldon.
Oh, sorry, Colin. I think the next one's yours, and I'm just going to take a sec to queue it up here. I thought I'd figured out how to move backwards and forwards in the slides, but I think I can only move forwards. So apologies.
All right, so we're moving on then to adapting your approach to dealing with tribunals. And as we've mentioned before, one of the things that you're going to keep in mind is the hearing style, the experience of the decision maker. How often do they sit? How many hearings? Last year, we did the first hearings on the Assessment Appeal Board that were conducted in 4 years. Not because there weren't any, but rather because they couldn't get enough people to sit on it to form a quorum for the tribunal. So look at the history of the decision maker and the tribunal itself. During the hearing, you want to check on the decision maker and take your lead from them about how you're doing or what they need from you, what kind of assistance they may need. So one of the challenges for people, for decision makers or lay decision makers, is dealing with objections. You may need to lend some guidance in how to address objections and also submissions. So courtesy really goes a long way in this regard. You may very well be the most knowledgeable person in the room, but use that knowledge to further the proceedings. And remember that the decision maker certainly isn't your adversary. Sheldon, how are you doing on the slide? So we're looking at your desktop at the moment.
Oh, are you? Oh, sorry. Okay. Thanks for pointing that out. I hope there's nothing revealing on there.
The other helpful thing when being before a tribunal, and again, depending on the experience of the decision maker, is draw a clear distinction between submissions, authorities, arguments. And this is doubly true when there is a self-represented individual on the other side who may blur the lines between evidence, argument, and submissions. And you need to pick your battles on that one. As is commonly the case with self-represented individuals, they may start introducing new evidence without realizing it as part of their argument. You may wish to intervene, but do so in a way that explains why you're intervening. One of the most helpful ways to guide the difference between submissions, authorities, and arguments is start off with identifying what the legal tests are and make your submissions specific to those legal tests. So set up the roadmap and then walk the tribunal through that roadmap. I find even for the most experienced of adjudicators, that's quite helpful. It keeps the issues focused.
Okay, so self-represented parties. This can be a challenge for both courts and administrative tribunals. Um, when I think of my experience with human rights, all but 2 of the cases I've handled in the last 6 or 7 years have involved respondents that are represented and complainants that are not. And so, how do you manage a hearing when that's the case? That's something that your administrative tribunal may have to deal with. You may be the one counsel that's on that matter with self-represented parties on the other side. I think there's a lot of writing out there about how to deal with situations like that. Some of it's come from judicial sources like the Canadian Judicial Council, but one thing you can maybe expect is that the tribunal is going to be more proactive in ensuring that the self-represented party has an opportunity to present their case, maybe more permissive about certain things like allowing evidence. In the human rights context, we've used what we call active adjudication techniques, and we presented on that before. So we would encourage counsel to be familiar with some of those things. Examples might include the adjudicator allowing self-represented people to make statements as opposed to having their evidence adduced through the typical direct examination, like just basically letting them tell their story. It might involve the adjudicator participating in questioning the witness. In other words, managing some of what would normally be a direct examination. So be aware of those things, and I would encourage any counsel to be prepared to be flexible on that front. Recognize that self-represented people are challenged to get through the process themselves and often intimidated by being there. And we do have ethical obligations as lawyers to make sure that we treat those individuals in a certain way and make sure they have the opportunity. So the next area we want to leave a little time for questioning, but we could not present this presentation today without saying something about virtual hearings in light of the fact that we may be seeing many more of them in light of the COVID-19 situation. So I'm going to just switch over to a slide that we have on virtual hearings. Just give me a sec. Colin, do you want to chime in on self-represented litigants while I do that?
I rarely see counsel in hearings that I conduct. Self-represented litigants can be most challenging when there is a counsel opposing them. If they're there by themselves and the other party isn't represented, it's easy to provide them with the opportunity to give their narrative, to give their story. When they feel that they're being watched or listened to by counsel for the other side, they become more nervous and more argumentative. So how opposing counsel communicates with them before and during the hearing has a great impact on that individual's comfort level and ability to effectively represent themselves, or more effectively represent themselves.
Yes, I agree with all that. All right, virtual hearings. So as we all know, we may be seeing more of these in our futures. Of course, as always, check the legislation, see if it provides for that. It might not specifically the tribunal might have the ability to set its own practices and procedures. So again, check their practices and procedures on the website. And there may be specific COVID-19 things that have been developed. My inbox seems to be always full of things from the CBA or Canadian Council of Administrative Tribunals about how to manage files and cases in the COVID-19 world. Eventually, some of those things are going to translate into hearing procedures being set up, I expect. I guess my observation on this would be that I would say tribunals are probably generally more open to the idea and a little less conservative than the courts have typically been. We've used them a lot. Tribunals use them a lot for pre-hearing conferences and sometimes even hearings even before March 2020. So, there's the usual qualifications. They're not a fit for every type of matter. I think there's still a overall sense that in-person hearings are preferable and reflect better the gravity of the process, especially if the decision is going to have a serious impact on somebody, like a disciplinary hearing. As counsel, you're going to have to assess whether there's any serious disadvantage to running something virtually as opposed to in person, and then assessing, how much you push forward for an in-person hearing, if that's even possible. So I guess the takeaway here is that as this may become a more cogent part of our reality, know your tribunal. Is it willing? Is it able to do virtual hearings? Does it have the means? Does it have the actual technological ability? With human rights, we have access to telemerge, which is kind of like Zoom here. If it doesn't have those things, can arrangements be made? If you're the one pitching for a virtual hearing, you might bring some suggestions as to how the technology can be implemented for your hearing. Can the technology be made accessible to the self-represented persons that may be involved in the hearing? Do they even have a phone? Do they have access to a computer with a camera? If you're the one pitching for the virtual hearing, you can get creative about ways to provide them access to those things if they don't have them. I think there will be some appetite for doing things that way, and maybe some of the reservations that we've had over the years will start to fade away. And with that, I'm going to turn it over to Colin. He's going to share some best practices that he's found from some resources that have been put out there on virtual hearings. These things are starting to, circulate in the world, and this is one cue that these things are out there. Colin, do you want to take it from there?
Thanks. Before I get into that information, I just wanted to mention that we've been doing video conference hearings in the territories for over 15 years. I can remember going over to the Northwest Tel building offices to conduct video conferences 15 years ago, and it only cost about $8,000 to do a half-day hearing. Luckily, bandwidth price has gone down a little bit. So a few of the best practices, there's certainly a lot more online resources for courts, tribunal, council, and parties around remote hearings or video conferencing. One of the good ones, and the title page is on the screen, Best Practices for Remote Hearings. You can find it on advocates.ca. It was produced as a cooperative effort between the Ontario Bar Association, the Advocates, etc. And it's a very good starting guide. Some of the best practices, both through experience and through all the materials I've been looking at recently online, is again, it's always a good idea to narrow the issues as much as possible. With remote hearings, with video conference hearings, it becomes critical to my mind. Agreed statements of facts, agreed upon law briefs, simplify the hearing so much. Narrow it down to what the decision maker is being asked to determine, and stick with as narrow issues as possible. Another good practice for pre-hearing matters is, if your client's going to attend the hearing, request or ask the tribunal if breakout rooms are available, so that you can use them with your client during adjournments. Again, the value of well-organized materials can't be overstated. The easier it is for the adjudicator to access documents, evidence, cases, the better it will be received. One of the formats that I really like is Adobe Acrobat Pro portfolios. And this allows all the materials to be put into one PDF document with tabs. So it's very much like that hard copy binder. And you can go to, in one or two clicks, not only a specific titled tab, but also a page within that tab. Another pre-hearing thing to keep in mind is prep your client about the process, including camera and mic use, muting, recording, screen captures, chat features, and the use of other electronic devices while the hearing is going on. For instance, if you're using a computer during a hearing, don't be seen pulling out your cell phone and answering text messages. The other thing to keep in mind is dress, something as simple as that. Dress as though you were going to be appearing in person. And as a cautionary note from experience, check your background before you sign into a hearing. During the hearing itself, there will likely be some level of technical difficulties. So be prepared with the backup phone number. Be understanding as others experience their technical difficulties and challenges. Assist when you can, but one of the most helpful things you can do is be patient. There's likely to also be unintended distractions during a hearing. Raising procedural objections should be used cautiously. And I'll give you an example. I recently had a pre-hearing conference with counsel on one side, self-represented on the other. During the pre-hearing conference, the self-represented individual's cell phone went off. He actually said, "Just a moment," muted and clicked off his video and took a phone call on his cell phone while the rest of us were just left hanging. So 3 minutes and 47 seconds later, he rejoins and apologizes. It was a very important call. So be prepared for just about anything. The other thing to keep in mind is hearing room management is far more challenging for an adjudicator in in a Zoom hearing than in an in-person hearing. So your assistance and cooperation will go a long way in hearing room management. So those are my gems. Sheldon?
That's many more than I would have thought of, but I also note that this best practices document has some very specific information about formats to use for video conferencing, like technical information. So it's a good resource, and I think there's lots of others like it out there right now, but this one's particularly good.
Good. Questions, comments? You're certainly welcome to submit anything through chat, or just if you have your video on, waving or raise a hand. Oh, we have one, Andrew.
Hi, good afternoon. I want to say, first of all, thank you very much. I thought this was really interesting and a terrific presentation, and thank you to the Law Society for putting this all together. I have to say, technologically, this has gone much more smoothly than 99% of these meetings I've had. So this is really well done. I had a question regarding kind of how lawyers should approach a situation where there is a self-represented litigant. And as I think you mentioned, Colin, not all of the tribunals are composed of legal professionals either. So it's not uncommon to wind up in a situation where there is a full-fledged hearing going on and you are the only lawyer in the room. And that then creates challenges around what battles do you pick? You know, when it appears that a self-represented litigant is about to make an error and the decision maker is going along with it, how do you determine what is worth arguing about and what is kind of raising the level of conflict in the room, and what is worth kind of staying silent on so that you don't, you know, inadvertently turn the process into something sideways?
From my perspective, it's the bottom line is, does it impact on the merits of the case? And does it impact on your ability to present your case? Everything else is it worth it? So you're right, it is picking your battles. And if you go after minor procedural stuff, it's going to drive you crazy and it's going to extend the process significantly. The core deciding factor, to my mind, is, will it impact your ability to speak to the merits of the case? Sheldon?
Yeah, I think all that's valid. And I think part of the challenge is to be self-aware of the sort of multi-role task that you have in that setting, because you're there to advocate for your client, obviously. But you also have a bit of a responsibility, I would say, to try to keep the tribunal on track, to assist the tribunal in fulfilling its role, which means you have to step outside the role of advocate to some extent to be able to objectively make submissions on that. And choosing the battles is critical, because if you insist on every possible objection that can be made, it's going to undermine your credibility with that layperson who's trying to, do their best to manage it. Most of these administrative decision makers understand that's their role, to manage it. So if it looks like you're taking over, they might resist, but in a way that's not helping the process. So choosing the battles is good, but another thing you can do is just register objections on the record, but not, let them go. If there are things that aren't going to impact you, but you still feel a need to say something, you can, politely register them on the record and say, but I'm not going to pursue that, or something like that. And then you've got, a fallback later for if you decide that this was more important than you assessed at the time.
Yeah, and I'll just add briefly, while there is such a thing as active adjudication, there really isn't a thing such of active lawyering. Your role is still based on your position, and while you can drop hints around process, you certainly don't want to be seen in advising the tribunal or the panel on how they should do their work. It can be framed in a nice way, like in the normal course, a tribunal would, or you may want to consider this. So stay away from affirmative direction, and I think you'll be okay.
Thank you very much. That's very helpful.
Okay, are there any other questions from anyone?
Great, thank you.
Okay, well, thanks everyone for coming, and hopefully we'll see you all again.
Thanks, everybody.
Thanks.